Today I'm going to try and help you guys with a writ of error objecting and dismissing order to remand back to state court. Okay? I hereinafter, the petitioner or plaintiff, one of the American people, hereby state the facts and objections and dismissal of magistrate order to remand back to the state court, as magistrate has made an error in judgment. Objection and dismisses the order under Section 25 and 27 of the Judiciary Act of 1789, as well said order is against the petitioner's wish. The maxims are clear in the matter. Please see the following: optima est legem quam minimum relinquent arbitor judice. I believe a lot of this is in Latin, guys, so if I'm pronouncing this wrong, forgive me for that. Okay. That law is the best which leaves the least discretion to the judge, and this is an advantage which results from certainty. Bacon de August SC APH 8. The magistrate did err in his belief that the magistrate's court did not have jurisdiction. The magistrate's court will find jurisdiction in the following, as well as the venue, due to the fact this is a contrivance over the statute. The magistrate said, and I quote, more importantly, even if the removal was timely filed, Derrick does not establish that his court, which has subject matter jurisdiction over the underlying dispute. Unlike state courts, which have subject matter jurisdiction over a broad assortment of causes and claims, the jurisdiction of federal courts is limited only to cases of controversy that are authorized by Article 3 of the United States Constitution and the statutes enacted by Congress pursuant, the state refuses to acknowledge the ruling deeming child support unconstitutional. Do the American people not have an honest court left? The petitioner has made repeated attempts to vary officials up to including the Attorney General, only to be ignored. First, this court has jurisdiction under 28 U.S.C. Subsection 1331. Federal questions jurisdiction arises pursuant to 42 U.S.C. Subsection 1983 and 1985 under inadequate training of subordinates. 2. Title 18 U.S.C. Section 242, deprivation of rights under color of law. 3. Title 18 U.S.C. Section 241, conspiracy against rights. 4. Title 42 U.S.C. Section 14,141, partner and practice. 5. Title 8, partner and practice. 5. Title 18 U.S.C. Code, subsection 1581, peonage. 6. United States Code, Title 42, Section 1988. Okay? This case particularly pertains to child support, ladies and gentlemen. And for those of you out there who are dealing with these insidious rats that are hell-bent on making sure that you're impoverished, let me help you out a little bit. Venue. Number 2. Venue is proper pursuant to 28 U.S.C. subsection 1391 because the defendant is a government official and the plaintiffs live in the district. Venue is also proper by way of Title 42 U.S.C. 1983 and 1985. Also, child support has been deemed unconstitutional due to lack in the federal law 18 U.S.C. subsection 228 having no provisions for the separation of powers. Plaintiffs are being ordered to obey a statute that is unconstitutional. Plaintiffs have suffered ill treatment and infringement of plaintiffs' unalienable rights to property, due process, and equal protection under the law. Now, one of the best claims that you can make is civilian due process of law violations. The penalties are very heavy for that, and it's extremely easy to prove that you've not been provided civilian due process of law, because these corporate agents and agency never provide due process of law. Almost never do I see a case where due process of law has been granted to the alleged defendant. Okay? And equal protection under the law. Plaintiffs have been threatened, suffered coercion, been illegally jailed, thereby denied liberty. Plaintiffs have been repeatedly subject to search seizures of property without due process of law. Plaintiffs have sustained physical injuries while in police custody. Plaintiffs have been put in state of an effort in futility by the actions of the commissioner. Plaintiffs have suffered illegal jailing since 1999. Attorney General and other defendants have been served a letter of intent. Note, all defendants are going to be sued in both defendants' private and corporate capacities for their fraudulent activity and actions. Claim 1. The facts of the law already say child support has been declared unconstitutional, so for the defendant's cause of action against plaintiffs, there is no jurisdiction in the matter. As child support was declared unconstitutional in state of Minnesota in Court of Appeals, C7 97 926, C8 97 1132, C7 97 1512, C8 98 33, filed June 12, 1998. The decision was upheld in the Supreme Court, State of Minnesota, in the Supreme Court, C7 97 926, C8 97 1132, C9 98 33, C7 97 1512, filed January 28, 1999. This alone constitutes that no jurisdiction could exist, because child support was found to be lacking any provisions for the Separation of Powers Act in the U.S. Constitution and both the federal and the state law. Plaintiff challenges the jurisdiction under Article 1, Section 8, Article 1, Section 8, Clause 17, pursuant to Trial Rule 12.1, lack of jurisdiction over the subject matter. 12.2, lack of jurisdiction over the person. Okay? Very important. As to whether or not these rulings and laws cited apply, one need only look here at the following rulings: Mills versus Deary. Okay, we went over that last night. U.S. 7 Cranch 481, 1813. The United States Supreme Court ruled that the merits of the case, as settled by courts of one state, must be recognized by the courts of other states. States' courts may not reopen cases which have been conclusively decided by the courts of another state. Later, Chief Justice John Marshall suggested that the judgment of one state court must be recognized by other state courts as final. Howitt versus Rose, federal law Supreme Court cases apply to state courts. Cooper versus Aaron, states are bound by United States Supreme Court case decisions. Alberman versus Booth, no state law or court can contradict federal court case rulings. Also, Article 4 of the U.S. Constitution states that each state shall give full faith and credit to the other state's laws. 12.8, the same action pending in another state court of this state. Then jurisdiction was simply assumed. Once plaintiffs were silenced by the threat of jail for contempt, which we know that if they're going to bring contempt charges, you need to challenge that, ladies and gentlemen, because you cannot be the judge, the jury, and the executioner, as well as the victim, okay? For challenging the jurisdiction of the court. So plaintiffs decide to see what case law on this matter denotes. It's Bosso versus Utah, Power and Light Company, 495 F2D 906910. Jurisdiction can be challenged at any time and must be proven, not assumed. Latana versus Hooper, 102T2D 188, Chicago versus New York, 37F SUPP 150. The court must prove on the record all jurisdiction facts related to the jurisdiction asserted. Also, see plaintiff's memorandum of points and authority on jurisdictional challenge. One need only look to the American jurisprudence to see what has been decided prior on any unconstitutional law and the duties of a court officer. American Jurisprudence, 2nd, 1964, Volume 16, Constitutional Law, subsection 177. Generally, statutes leave the question that is purports to settle just as it would be had to the statute not been enacted. Since an unconstitutional law is void, the general principles following that it imposes no duties, coffers no rights, creates no office, bestows no power or authority on anyone, affords no protection, and justifies no acts performed under it. A contract which rests on the unconstitutional statutes creates no obligation to be impaired by subsequent legislation. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. Indeed, insofar as a statute runs counter to the fundamental law of the land, it is suppressed thereby. It is said all persons are presumed to know the law, meaning that ignorance of the law excuses no one. That's a maximum of law. You'll find that in Lord Coke. If any person acts under an unconstitutional statute, he does so at his own peril and must take the consequences. Page 403 and 405, 16 Am Jurisprudence, 2D, Constitutional Law, Section 70. No public policy of a state can be allowed to override the positive guarantees of the U.S. Constitution. 63C, Am Jurisprudence, 2D, Public Office and Employees, subsection 247. As expressed otherwise, the powers delegated to the public officers are held in trust for the people and are to be exercised in behalf of the government or of all citizens who may need the intervention of the officer. Furthermore, the view has been expressed that all public officers within whatever branch and whatever level of government and whatever be their private vocation are trustees of the people and accordingly labor under every disability and prohibition imposed by law upon trustee relative to the making of a personal financial gain from a discharge of their trust. That is, a public officer occupies a fiduciary relationship to the political entity on whose behalf he or she serves and owes a fiduciary duty to the public. It has been said that the fiduciary responsibilities of a public officer cannot be less than those of the private individual. Furthermore, it has been stated that any enterprise undertaken by the public officials which tend to weaken the public confidence and undermine the sense of security for individual rights is against public policy. Okay, public policy is not public law. Let's not get them confused. The law is clear. The magistrate has a fiduciary duty to uphold the Constitution and the oath taken by the magistrate. Rule 1.1 of the Judicial Code of Conduct states the magistrate must uphold all laws and their oath. Again, despite plaintiff's repeated notifications of the unconstitutional statutes and the laws, plaintiff has been jailed by the state courts, so remanding this case would subject petitioner to further criminal acts of state commissioner. Okay? Claim 2. Second issue is the 13th Amendment. Article 1, Section 10, Clause 1 of the United States Constitution says, no state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver a tender in payment of a debt, pass any bill of attainder, ex post facto law or law impairing the obligation of contracts, or grant any titles of nobility. As well here in Article 1, Section 9, Clause 3, no bill of attainder or ex post facto law shall be passed. The next question for one to ask, what exactly a bill of attainder is? The following is how plaintiffs have found it described in law in fact. Bill of attainder means legislative act, no matter what their form, that apply either to named individuals or to easily ascertain members of a group in such a way as to inflict punishment on them without a judicial trial. United States versus Brown, 381 U.S. 437, 448, 49, 85, SCT 1707, 1715, 14, and the list goes on. An act is a bill of attainder when the punishment is death, and a bill of pains and penalties when the punishment is less severe than death. Both kinds of punishment fall within the scope of the constitutional prohibition, U.S. Constitution, Article 1, Section 9, Clause 3, as to Congress, Article 1, Section 10, as to state legislators, Bill of Pains and Penalties, see Bill of Attainder. This refers back to the Indiana Child Support IC 31166 law and the federal law 18 USC subsection 228 is a Bill of Attainder law. The laws do allow punishment without a trial by allowing the suspension of plaintiff's driver's license without a trial. All while it is clear to all these actions stated clearly fall within the guidelines of the following federal laws. Title 42 USC section 141, partner in practice. Title 2, 18 USC section 241, conspiracy against rights. Title 18 USC section 242, deprivation of rights under color of law. This court has jurisdiction under 28 USC 1331. Now 1331 is the original jurisdiction of the federal court, which supersedes all other courts, okay? Because the federal court was the first one created. It has the original jurisdiction, okay? Question jurisdiction arises pursuant to 42 USC 1983 and 1985. Now, you guys know what the 1983 suit is, and you want to bring suits in equity with a chancery court before a chancellor. You don't want to deal with the corporation. You want to deal with right and wrong, not their crazy antics of what's politically correct. Let's go here. United States Code Title Section 1988. Let us examine what the American jurisprudence says about such actions being taken. 16 Am Jurisprudence 2D, Constitutional Law, Section 155. Since the Constitution is intended for the observance of the judiciary as well as other departments of government, and the judges are sworn to support its provisions, the courts are not at liberty to overlook or disregard its commands or counteract evasion thereof. It is the duty in authorized proceedings to give full effect to the existing Constitution and obey all constitutional provisions irrespective of their opinion. Okay? As to the wisdom or the desirability of such provisions and irrespective of the consequences, thus it is said that the courts should be in our Excuse me. I'll have to take this call here in just a second. Existing Constitution and to obey all constitutional provisions irrespective of their opinion as the wisdom of the or the desirability of such provisions and irrespective of the consequences. Thus it is said that the courts should be in our altar to enforce the provisions of the United States Constitutions and guard against their infringements by legislative fiat or otherwise in accordance with these basic principles. The rule is fixed that the duty in the proper case to declare a law unconstitutional cannot be declined and must be performed in accordance with the delivered judgment of the tribunal before which the validity of the enactment it is directly drawn into question. If the Constitution prescribes one rule and the statute then another in a different rule, it is the duty of the courts to declare that the Constitution and not the statute governs in the case before them for judgment. Yet here again the defendants have failed to observe their duties under their oaths taken in Article 6, Clause 3. In the interest of fairness, let us examine what the American jurisprudence says about such actions being taken for a second time. 16 Am Jurisprudence, Constitutional Law, Section 260. Although it is manifested that an unconstitutional provision is in the statute is not cured because included in the same act with valid provisions, and that there is no degrees of constitutionality. Owen versus Independence, 101 volume Supreme Court Reports 1398 and 1982. Maine versus Thiobato, 100 volume Supreme Court Reports 2502, 1982. The right of an action created by statute relating and to deprivation of rights under the color of law, a right secured by the Constitution and the laws of the United States, and claims which are based solely on statutory violations of the federal laws and applied to the claim that claimants had been deprived of their rights in some capacity to which they were entitled. Officers of the court have no immunity when violating constitutional rights from liability. When any public servant violates your rights, they do so at their own peril. Despite the defendants being informed of the unconstitutional nature of the state and federal statutes, defendants decided to move forward in the chosen action, which shows clear intent, with malice and complete forethought of the defendant's actions. However, so as to be entirely fair, let's examine the American jurisprudence for the third and final time to see the decisive action that should prevail. The decisive action that should prevail. American jurisprudence, 2nd, 1964, Volume 16, subsection 411, Bills of Attainder. Legislative acts, no matter what their form, that apply either to named individuals or to easily ascertainable members of the group in such a way as to inflict punishment on them without judicial trial, are bills of attainder prohibited by the Constitution. The singling out of an individual for legislative prescribed punishment constitutes a bill of attainder prohibited by Article 1, subsection 9, Clause 3 of the Federal Constitution, page 751 through 752, section 177 generally. The general rule is that an unconstitutional statute, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the time of its enactment and not merely from the date of the decision so branding it. An unconstitutional law and legal contemplation is as inoperative as if it had never been passed. So in our examination of the American jurisprudence, there is no doubt left of the validity of the veracity of the claim which have been made. The malice and forethought and legislative as the officials in question was informed of the unconstitutional nature of the statute in question. This would mean any instance of remand would bring harm to the petitioner, as proof has been shown that the petitioner cannot receive a fair hearing in the state court. Bouvier's Law Dictionary, 1914 Maximum, page 2149. No legislative body or man can convey any authority or jurisdiction he does not possess over common rights vested by God and another. Because legislative powers are limited, all powers derived from the legislative act are limited. The petitioner has now established the fact consent is needed. The petitioner has not consented to the magistrate to allow and remand order. Third claim, facts of conflicts of interest. First claim, claimant has identified themselves as the state of Iowa, Indiana, whatever you want to call it. Therefore, this court is improperly set due to the fact that in all cases in which a state shall be a party, the Supreme Court shall have original jurisdiction. Second issue, here is the ruling of Hoke versus Henderson, 15 NC 1525 AM DEC 677. The statute which would deprive a person or persons of property without a regular trial according to the use and customs of common law would not be the law of the land. There is a common law principle which states that for there to be a crime, there must first be a victim, a corpus delicti. In the absence of a victim, there can be no crime, and the state cannot be the victim. This ruling is clear and to the point. There can be no criminal charges without a victim, and the state cannot claim to be a victim. Also see the following. For a crime to exist, there must be an injured party or corpus delicti. There can be no sanctions or penalties imposed upon one because of the exercise of one's unalienable rights. That's Shara versus Cullen, 481 F 945. So you guys see where this is going. And I'm not going to finish this out, and I know that drives you guys nuts, but it goes into Deary versus Mills. It also goes into the appeals court with the Supreme Court in Minnesota. And we have Dallas versus Mitchell, 245 SW 944. And so with that said, I hope that helps you guys out that are out there challenging the status quo of these tyrants that have seemingly taken over the judiciary. Justice doesn't stand for justice anymore. It stands for just us. And like George Carlin said, it's a tight-knit group of people, and you ain't in it. Have a great day.